Okay, all right. Counsel, you'll each have 15 minutes for your argument. Counsel, for Ms. Shimoda, you will have the opportunity for a 5-minute rebuttal. We ask that you state your names before you begin your argument, as we are tape recording the proceedings. And the podium does move up and down. It looks like that's pretty comfortable for you, but you can adjust it if you'd like. We'll wait for Judge Stauber before you start your argument. And hopefully we won't be waiting long. You may proceed.
Thank you. May it please the court, opposing counsel. My name is Stephen Grigsby, and I represent the appellant in this matter, Michelle MacDonald Shimoda. I've written what I think is, at least on average, a lengthier brief than I'm accustomed to. So what I'd like to do is to really, I think, focus in on, what are the most concise principles of law that support our position that there was reversible error committed in this trial. With respect to cameras in the courtroom, this is indeed, I think, a novel issue. For both I and opposing counsel, we're unable to find a single case that was even raised the issue before of what the Sixth Amendment's right to a public trial has to do with the right of a defendant to have the cameras in the courtroom.
When you say case of first impression, you don't just mean in this jurisdiction.
I haven't found anything anywhere in all of Anglo-American jurisprudence that really deals with the relationship of cameras to the Sixth Amendment right of a defendant.
Doesn't that give you a bit of a hint as to whether or not the Sixth Amendment includes a right to have cameras in the courtroom, that is, a public trial means public beyond the courtroom?
No, it doesn't give me a bit of a hint, and for the same reason that I imagine Ernesto Miranda's lawyer was probably asked the same question when he proposed there was a warning required. At some point, society changes. At some point, the word public refers to a different constituted entity than it did when the word was used.
Why is that so?
Excuse me?
Why is that so? Why is it that the notion of what is a public trial changes because technology changes?
Because the way the public is constituted changes by the way technology has changed. When you have to ride a horse to a courtroom somewhere, it's a lot different than today. People don't use horses. They do Skype to have international conferences.
No, they don't use horses. They have cars. So doesn't that counter your argument? It's actually easier for the public to show up in the courtroom?
The cars make it easier, but if that's the case, if the cars make it easier, then cameras make it a lot easier. YouTube makes it easier. Skype makes it easier. Today, we communicate digitally.
No, I mean, the argument is undercut. Not that there's technology that might extend what's happening in the courtroom further out, but the idea of a public trial is that the public can come into the courtroom. At least that's my understanding of the law. And if you're asking us to cut some new swath out of the existing law, it seems to me that there's got to be some precedent somewhere that suggests in the principle of what is a public trial, the concept that you're asking us to adopt as a matter of law.
I think it is, and I think it's implicit in the notion that the entire purpose of a public trial is not some arbitrary limit about the size of a courtroom, that to a large extent a brick and mortar courtroom was the only existing way in which a court could have occurred. Brick and mortar has gone the way of the digital way in which people relate to various things that were done with physical presence today. People communicate. The public accesses virtually everything it does today on an unprecedented scale with the development of technology. A courtroom with brick and mortar was a technology, required brick and mortar. It
wasn't a technology, it was a space where the public trial was to be held, where the public can come and attend. If your argument has merit, it seems to me that the constitutional right expands every time there's some new technology. So if there's holographic technology, then where you can project images of everyone in the courtroom, that every defendant then, as soon as that technology hits the opportunity, there's a constitutional right. Not just technology, not just a matter of convenience, but a right.
The purpose of the right is to make what happens inside of a courtroom accessible to the public, and there is, I don't think there's any rational argument that somehow excluding a camera from a courtroom serves the purpose. In fact, I think the argument we've made that more access to the courtroom, more light upon what happens, furthers the purpose of the public trial, which is to allow the people who vote for judges, the people who are interested in fashioning public policy, the people that live in a democracy and are ultimately responsible for electing and recalling those who don't serve their will, are better served if they have more access to it.
Well, since the technology exists and it's a constitutional right, what you're saying is a party doesn't even have to ask for it. It's a constitutional right, therefore the court has to provide a broadcast to the public of every trial that goes on in every public proceeding.
No, because like any right, it can be waived by not being raised.
So let me ask you a quick question here. You want to set up your own camera in the courtroom? That's what you want to do? Or,
No.
or do you want to have the public, as Judge Ross indicated?
Under the specifics of this case, there was a request by somebody from the media to have a camera in the courtroom. And so the issue was simply limited to the specific facts. But this was somebody who was representing the media. This was somebody who wanted to have the camera in the courtroom. And this was something that was specifically raised by the defendant in this case about her right to have that if the media wanted to.
So why is that your client's right, not the media's right?
Because the First Amendment gives the media right, the Sixth Amendment gives the client the right. They're just distinct scope of rights.
Right, I'm just trying to get a sense of whether this concept has ever been applied in other settings. There's other media, there's print media, for example.
Sure, and then I think that's what's one of the argument that if there already is print media, there are already reporters who are allowed to come to the courtroom. They make these caricatures.
No, that's not my question. My point is, has it ever been, granted, video technology may be new, but print technology is not new. Has it ever been the case anywhere where the constitutional rights that you're discussing have merged in the way that you're applying them here, or you want us to apply them here, as to print media? That is, where a defendant can say, the newspaper was denied access to the court, therefore, because the newspaper's First Amendment rights were violated, my Sixth Amendment rights were violated.
I understand the question. And here's the answer, is that no, because these cases have simply by contingency and happenstance been litigated by the First Amendment issue with respect to the media. There has never been a case in which the media has been excluded and the defendant has actually raised this as an issue. If you don't raise it as an issue, it doesn't magically come before the court. In this case, the defendant did raise this as an issue.
But doesn't it make sense to you that the reason it's not been raised as an issue is that you only have your own rights? You don't have the right you can't lob on, a defendant can't lob on to a media outlet's right, First Amendment right.
Correct, but this is no different from the very, very long tradition of closure of the courtroom. In that case,
But counsel, here's the issue we have, because we're governed, the latest from the Minnesota Supreme Court is the Brown case, which talks about what is a closure of the courtroom, and we're bound to follow the decisions of the Minnesota Supreme Court. And there's nothing in that case that suggests that there was any kind of courtroom closure here.
It is a courtroom closure in a way of looking at it, because you're excluding from the courtroom a specific type of media that would allow the public access. But back to Judge Ross's question, it's always the case when you close the courtroom, a third party is excluded from coming in, and that still has always implicated the right of a defendant.
Because the defendant has a right to a public trial.
That's correct.
And the person who wants to come in, can come in.
Unless the courtroom's closed. So it's the closure of the courtroom that violates a defendant's right by excluding a third party. There is no other way to understand the notion of a closure.
But there was no third party here who was excluded. The person in the media can come in. They just weren't allowed to use their apparatus. There was no member of the public who said, I really would have liked to watch this on Channel 5.
And I'm suggesting that's a distinction without a difference, because if the purpose of not closing the courtroom, and even in the very small ways in which the closure of the courtroom it implicates transcendental rights of a defendant that are clearly anchored in the Constitution, the rationale here would be a defendant has no right to have the public have access to the courtroom, but for the way a courtroom simply happens to be constructed. That in the 21st century, when a large part of our mediation, the large part of our dealings with things happens digitally. I mean, there's a camera in the courtroom right here. There are already cameras in the courtroom for security purpose. The only possible goal that excluding the cameras in the courtroom would serve would to simply deny the expanded opportunities for public access.
No,
Moreover,
that's not true. I mean, there's evidence that cameras in the courtroom can negatively affect court proceedings, especially when you have children who have been abused, or, I mean, there are many circumstances, and there's research out there on both sides that it's not just a benign thing.
well, that may be, and let me address it in two ways. First of all, there are a lot of jurisdictions that have cameras in the courtroom all the time,
Sure.
and there are convictions and acquittals obtained, and justice goes on. So if this were the case, I think that begs the question, are all of these trials now invalid across the states that allow them? And secondly, there's the issue that it's not only that there are these cameras in the courtroom, but when a defendant in Chandler said, that speculative possibility that I will not get a fair trial and it violates my due process if you insist on cameras over my objection, the Supreme Court was very clear that that speculative possibility is not enough to say the defendant's rights were violated. Well, that argument cuts both ways, and that is that speculative possibility that cameras may lead to showboating or the other concerns the court just mentioned cannot be sufficient to defeat the right of a defendant to have the public access through cameras.
What remedy are you asking on
I'm
that
asking,
issue?
I'm asking for a new trial. Okay. Now, if I can, there are a couple of other issues that I'd like to address if I may.
I'm just curious, which of those four issues that you've raised do you feel is the strongest position for reversal?
Well, I can tell you what I think is the weakest, but I think the 3 out of the 4 are equally strong. But let me address the issue of
Which is the weakest?
the weakest is the Minnesota statute 16991. That I think is the weakest issue. But I think the strongest issue is really, and I really want to put this before the court, is that the regime by which people are convicted of refusal requiring a jury to find probable cause is unworkable, and at some point this court is going to have to void this procedure. And I say this for this reason. I think the most concise way to put it is the way in which Supreme Court jurisprudence has defined the standard of probable cause. It defines it as not being of a specific quantity, not being clearly definable.
I don't quite understand your argument. Are you arguing that probable cause had to be determined by the court because it's generally a legal question?
What I'm saying is probable cause was always determined by the court until there was this conflation of implied consent and substantive criminal law in Minnesota.
What I'm asking you now is the argument that you're forwarding now, are you saying that the court should have been the entity making the determination as to probable cause?
No, that would clearly violate the Sixth Amendment right to...
I'm lost as to what your argument actually is.
My argument is that it's simply not something that is susceptible of a jury determination.
So you're saying that the element shouldn't be part of the statute?
The element is unworkable. Absolutely, it violates due process because for precisely the way...
I didn't see a due constitutional challenge to the statute.
I think it's implicit in the way I raised it before this court that it's unworkable. If it's not workable, that implies due process. And I'll tell you the specific way in which I raised it.
Well, I'm going to push back a little bit. If you don't make a reference to the Constitution, a provision in the Constitution, and just sort of hint that the statute's unworkable, and then attempt to make a due process argument, at oral argument, I think there's sort of a due process problem with that if you haven't alerted your opponent to what argument you're going to be making.
But I have, and I'll tell you why I have. Because I recited cases in which vagueness defeats a very important due process issue. That is in the brief. I cite the cases that state vagueness, and I cite them supporting it with Maryland versus Pringle, where the Supreme Court of the United States says probable cause cannot be defined. It cannot be defined. And if that is true, and I think we have to accept what the United States Supreme Court says is true, then a person cannot know what it is precisely they are forbidden from doing that is vague, that is in the brief, that is a due process violation, even if I don't use the term.
So you're making a facial challenge to the statute. The statute is unconstitutional, period.
I think that's one way to raise the issue. I think the other way to raise it is in terms of
I mean, that's the argument you're making now.
That is the argument I'm making now, and I think that this was the same argument I made to the court when I said it's unworkable, when I said that you can't avoid the vagueness, when I asked for a different instruction, and the arguments I made in the brief to this court to say that a person simply is not on notice about what they can or cannot do when the specific thing that they're forbidden from doing is not susceptible, period, metaphysically, intellectually, of any definition whatsoever.
So just so I'm clear, you're saying that probable cause lacks definition.
Correct.
So in the million or so cases that have been decided by every appellate court and every district court determining when probable cause has occurred, you're saying that's all just an illusion.
No, it's a proper judicial determination. It's not something a jury can do, and it's not something a person can be held to account for criminal punishment.
So it is susceptible to reason. You're just saying, that gets back to my original question. I asked you whether it was the court that should have decided the issue instead of a jury. I thought you were saying that probable cause can't be determined by anyone because it's amorphous.
Well, it is, but I think that this is a sort of an amorphousness that's tolerated in the Constitution and our Supreme Court jurisprudence. The difference is this. It's one thing to say that a judge can determine it. It's a thing altogether different to say that a jury must do it, especially when the court itself has said, these are not my words, it's Maryland versus Pringle that says it is not susceptible of definition.
Okay, Mr. Grigsby, your time is up, but you will have the opportunity for a 5-minute rebuttal. Counsel for respondent.
Thank you.
May it also please the court, Benjamin Colburn, Colburn, appearing for the respondent, City of Rosemount, State of Minnesota. Just want to make a few comments with regard to the issue that, at least thus far, seems to have dominated the discussion, which is the issue of the right to public trial. I'll certainly make my best attempt not to regurgitate the contents of my brief, which certainly the court has reviewed. And I think I do take issue with at least one comment of Mr. Grigsby insofar as I think he asserts that by barring cameras from the courtroom, that the only possible goal of that is in some fashion to deny defendant her right to a public trial. And I think what we need to consider there is what really the goal is of the judicial system in a trial, which for all practical purposes is the proper administration of justice. And what needs to occur is certainly the defendant has a right to public trial. There was no closed courtroom at any point in this matter.
You would agree, though, the more open the courtroom, the more scrutiny the court is under and the process is under, and the more the constitutional right is vindicated.
I do generally agree with that statement, yes.
So what's wrong with the argument that there's a constitutional right to cameras since they forward that?
I think it needs to be balanced against some other very important competing interests, including where the attention of the judge is focused during the administration of trial. Obviously, the judge's role is to ensure that proper procedure is followed by both attorneys, court attendants, jurors. It's important to remember where the jury's attention is focused, whether they're focused on the cameras in the courtroom or any movement associated with that.
But you certainly could put a camera in a courtroom that's pretty surreptitious.
Certainly, that is an option, absolutely, yes.
The jury might not even know about it.
I suppose that is possible, although...
And all the concerns you're raising could be raised about people in the courtroom.
Well, this is true. However, people in the courtroom aren't going to have the same ability to put a clip out on, as I think counsel referred to, YouTube or some other social media, and essentially make, for lack of a better term, what I think would be a circus of the proceedings. I think there's an issue with potentially affecting the testimony of witnesses as well. Again, certainly your counter may be, okay, if the camera is concealed or not immediately obvious, would there be an effect? But of course, we also have an issue with regard to the witnesses' safety, whether or not they're willing to expose themselves to the risk of public scrutiny in that fashion, beyond simply what occurs in the courtroom and the media, which was permitted to be there. I think fundamentally the most important thing here is that the courtroom never was closed. The door was open, all members of the public and media were free to attend, and indeed they did. There was no one that was barred from attending this trial, and at least anecdotally, I know that there was at least some degree of media coverage of it. So I find it, I think the other impact on a potential jury pool is if for some reason that a retrial is necessary, again, in today's sphere of media, there's a greater risk of tainting a potential future jury pool if a retrial becomes necessary by virtue of media coverage that may focus on one aspect to the exclusion of others, which certainly I don't think would occur if someone is actually attending the trial in person.
Can you discuss the statute that this immediately brought before a judge?
Certainly, yes, that's the 16991, and obviously it boils down to exactly what you say. What do we consider to be immediately? It appears, at least on its surface, that the language of 16991 doesn't give us further guidance beyond immediately. But we can look to other statutes, of course, to look at specific procedures that are permitted when a person is under arrest for a DWI or other matters.
Don't we usually look to other statutes only if the plain language lends itself to an ambiguous interpretation?
I think that's correct, although, and I will agree that case law is somewhat scant on this issue. As I did mention in the brief, I think by example, the Hendrickson case indicated that an overnight detention of a DWI defendant was permissible because of the specific arrest procedure in the statutes for a DWI case when someone's been arrested on a probable cause basis.
Was the specific reference to immediacy brought up in that case or discussed in that case? Or just
I don't believe they specifically had a discussion with regard to immediate.
Neither party gave much of a legislative history on that provision. Any guidance you have for us as to the background of that statute? It does seem rather peculiar.
I agree, and I'm at a loss at this point to provide you with legislative background on that. My apologies. Nonetheless, I think at least given the two cases that I think are reasonably on point between Galarno and Hendrickson, that it appears as though once a person has been arrested for probable cause DWI, that the provisions for reading of the implied consent advisory and subsequent request for testing would, I think, at the very least, be an intervening matter that would need to be taken care of before the immediate audience could possibly be
Why would that
granted.
have to be done first?
I
I mean, you have 2 hours under the statute to complete the chemical testing, and you can do something in the immediate and still have that 2-hour period.
Well, I think that that would be an interesting setup to try to develop. Obviously, to some degree, justices judges are labeled on call, and I think there's now, based on some recent case law, obviously a scramble of sorts to give that system its workout in an effort to seek a warrant when an officer wishes to obtain a blood test, for instance.
This panel doesn't know anything about that.
Certainly not. Obviously, that's something that would have to be developed, and at least on its face, I mean, we're left without too much more to determine what immediate means. However, accepting the idea that immediate gives someone a pre-testing right to a judicial audience for all practical purposes, also directly contravenes the DWI law as it stands.
What's your sense of the statute? And was it immediate? I know you haven't done the legislative history, but is it intended to make sure that there was an arraignment that was available to a defendant within a reasonable period of time? I guess it's probably an unfair question if you haven't done the research as to the history, but.
I can only speculate on that, of course. I tend to think that this, in conjunction with the established rules and procedure pertaining to misdemeanor as opposed to petty misdemeanor arrests, that it is essentially a safeguard so that law enforcement officers wouldn't necessarily take someone into custody when it's either a petty misdemeanor situation or a misdemeanor where the certain aspects are not present, that someone is a direct risk to commit further crime or would not respond to a summons or citation. I have to imagine that's where it came up. In any event, I hope I don't mean to refocus if there was a further
Well, I'm just
follow-up there.
one other question on that statute.
Yes.
Even if, and I don't know this, the statute doesn't give a remedy for a failure to the shall present to a judge immediately. It seems to be assumed, at least in the appellant's argument, that the failure to follow that procedure, if the procedure is required, and immediate means what the appellant is asserting, that there would be effectively a sort of fruit of the poisonous tree. Nothing, all the process that goes on after that is unconstitutional or violation of the statute. What's the state's position on what the remedy would be?
If there were a violation of
Yes.
16991?
Do you concede that the a violation remedy would be a reversal?
Oh, well, needless to say, I do not concede that.
Why not?
I think that well, particularly in this case, I think I would say that the defendant was, after being essentially read the implied consent advisory and put through the procedure, that she was later actually released without being held for court or to see a judicial audience. So certainly there's no risk of undue detention there in this matter. As far as a remedy goes, I mean, first of all, I wouldn't concede that there was a violation in this matter. Perhaps that goes without saying, but you know, I think it seems like calling anything happening subsequent to that, I mean, at worst, it's a de minimis violation when her detention was delayed only insofar as to read and put her through the implied consent reading and subsequent testing procedure. I don't see that any actual harm has come of this. I think you raise a fair question because you're right, the statute is silent as to a remedy. But to simply throw the entire matter out when we have a specific statutory scheme for the police officers to follow, which they did exactly do, goes far above and beyond what I think is reasonable there. With regard to any other matters, certainly we've got a few other issues that have been raised, and I'll try to comment at least briefly upon them. First, with regard to the test refusal jury instruction, it seems to me as though there are three basic areas in which the court's instruction, what the court's instruction as to refusal needs to cover. That would be the specific observations and details of the incident, the factual circumstances that the officers gleaned from their investigation, that the jury is also instructed to consider the totality of circumstances by an objective standard from the point of view of a reasonable officer, as well as whether the officer has an honest and strong suspicion that a crime has been committed. These are the 3 points that come from the copy case. And while the judge in this matter did not give the pattern jury instruction, nor of course appellant's suggested instruction, I would certainly comment that the instruction that the court did give does cover all 3 points that are raised in the copy case as to test refusal. I find it a bit unwieldy for counsel to suggest that somehow which I think he is suggesting, that the statutory scheme simply be thrown out for a jury's inability to contemplate or evaluate whether the state has proven that the officer has probable cause to make the arrest. This is not an easy subject, but I think we shouldn't sell the intellectual capabilities of a jury short. They have as much time as they need to reach a decision. If they have questions, certainly they can raise them, and the judge may or may not answer them in court.
Can you think of any other situation where a jury is called upon as a matter of fact to make what is ordinarily a legal determination as to the quantum of evidence, whether it's preponderance of the evidence, probable cause, reasonable suspicion?
To be frank, I do not. I think this test refusal law is a bit unique in that regard. But nonetheless, certainly the jury's in the best position to hear the testimony of the officers, to evaluate whether they are credible, to see if they've observed simply one indicia of intoxication or multiple indicia. That's what they're there for. And I think that, again, the implied consent and the test refusal law has come under great scrutiny of late, of course. But for some current pending matters with regard to threatening refusal and demanding a blood test, it has held up. And therefore, juries are still in a position at this point to make that determination. And as long as they cover the 3 points that are raised in the copy case, I think we're on very solid ground there. So, and as a final matter, counsel has raised a question as to whether the evidence was sufficient to support an obstructing legal process conviction. I think one of his points there is whether or not the state had proven an element of the charge, whether the officers were performing an official duty. And I think I'd just simply point to the officer's testimony, both of whom testified as to what I beg your pardon, shall I continue or?
You may finish your answer.
Thank you. As to what their role was in employment, as to what their duties were in regards to that role, and that they were performing their duties on the night of this incident. So I think that argument fails.
In the attempt to make the arrest?
Yes, sir. Your Honor, pardon me.
Okay,
Thank
thank
you.
you. Thank you, Mr. Colburn. Mr. Grigsby, your 5-minute rebuttal.
Thank you very much. Just briefly.
Mr. Grigsby, let me ask you about I think which is your weakest argument about them being taken to a magistrate immediately. How are you going to do that in northeastern or northwestern Minnesota in small communities?
I don't think you can.
That's right. Thank you.
With respect to the state's entire argument about cameras in the courtroom, that is distracting, so on and so forth, well, the truth is that the states are the laboratories of the Constitution. And there are plenty of cameras in the courtroom that are all over YouTube. They've become part of the culture, and there has been no infirmity of any verdict or anything that happened as a result of the presence of cameras in the courtroom.
But aren't you talking about a policy matter then? I mean, what makes it a matter of constitutional right? Because even in this case, if everybody had agreed, there would have been a camera in the courtroom. It just seems that maybe as time goes on and we become much more accustomed to these kinds of proceedings, but it seems to me there's a huge leap between it being a good idea as a policy matter and someone's constitutional right.
And I think that is essentially simply taking the novelty of the fact that they're not in the courtroom and then reiterating it as something that's going to take some time to get used to. At some point, there's going to be a stark leap between a camera in the courtroom or not. What I'm suggesting is that it's mandated by the Constitution because the cameras are merely an instrumentality by which the public has access to the courtroom. It's as simple as that. All of the concerns about the wieldiness of the cameras, their distraction, were technological concerns that are largely overcome today. that in essence, what you're saying by excluding the cameras in the courtroom is that drawing caricatures by a person and then putting them on the news is perfectly fine. Having a blogger, having a member of the print press edit things and tell a story is perfectly fine. But somehow the most objective reproduction of what actually happens is somehow problematic.
I think you're missing the issue. I mean, I don't think, what we don't have is a Supreme Court decision or any appellate decision, as far as I know, that says a defendant has the constitutional right to a caricature artist, since that's the example you gave. I mean, again, I think the intersection that you seek to have us find meaningful is the right of the defendant to a public trial and a reporter's right to use media in the courtroom. And I don't see the two merging, I have to be honest with you.
Now, there's a lack of authority that the court points out. There is no case in which a member of the press wanted to go to the courtroom and the defendant said, I have a right to a public trial, you have to include him. But that's because it's so rudimentary, it's never been raised.
It's not just a lack of authority for me. I have a logical disconnect, a principled disconnect between the valid right, the very important right to the media to have, the First Amendment right to have access to the courtroom and a defendant's right to a public trial. I see them as distinct.
Well, let me try to bridge that gap, I think, logically. The public trial simply refers to public access. It is largely illusory to take the historical, technological brick and mortar and the doors as sort of the only closure, and then to treat closure with respect to other forms of media as simply some sort of odd metaphor. The truth is, the public should have access. There's only so many people that can fill a courtroom, simply by the way that the courtrooms are constructed. The cameras simply allow the public, who is now constituted differently. The public is constituted through relationships, through digital media and so forth. The public has to have access, and is ultimately an arbitrary way of excluding the public by suggesting that the instrumentality of cameras has never been mentioned before. At some point, it's got to be mentioned.
If your theory is correct, that would mean that if a small courtroom were full and individuals wanted to attend the trial but couldn't because the courtroom is full, your view, I think, would require us to hold, or require the court to hold, that the defendant has a constitutional right to that court being moved to a larger area so that more people can have access to it. And again, I don't see the case law that would support that, even under pre-video technology.
It wouldn't, and my time's run up, but just if I could,
may answer.
one response is that is exactly a limitation of technology, the space of a courtroom, that has changed now with the existence of digitization. That space can be essentially digitized, and that is no longer the problem, but the solution to it is cameras in the courtroom as opposed to not having cameras in the courtroom. Thank you.
Yes, thanks to both counsel for your presentations. The matter will now be taken under advisement, and we'll issue our order within our 90-day timeframe.